going to introduce our speaker today. Pamela Thakur is the managing attorney of Thakur Law Firm, APC, and is the former chair of the Orange County Bar Association healthcare section. Thakur Law Firm is a full-service law firm that represents physicians and their practices in several different aspects of healthcare, business, and employment law, including federal and state laws and regulation, medical board representation, HIPAA compliance, creations, mergers, sales, and acquisitions of healthcare practices, and more. Her employment litigation experience includes defending against class action and individual claims for wage and hour violations, wrongful termination, discrimination, harassment, retaliation, and trade secret misappropriation. From 2017 to 2019, she was selected by her peers as a rising star for Super Lawyers and Super Lawyer for 2020 and 2021. In addition to her litigation work, Pamela advises businesses and corporate clients on a whole array of employment issues, including in preparing and updating employment policies, drafting employee handbooks in compliance with the latest changes in state and federal employment laws, as well as assisting in disciplining and terminating employees and complying with leave and disability rules. Pamela also provides seminars for employers on best practice compliance and to assure compliance with California's mandatory supervisor employee harassment training requirements. And with that, I'm going to pass it on over to Pamela. Thank you.
Hi, good afternoon, everyone. It's a pleasure to be presenting today. I've had the honor of working with the medical associations for over a decade, starting with Orange County Medical Association, Los Angeles County Medical Association, and then Riverside and San Bernardino Medical Association. So my practice, although we practice in a number of different areas, particularly quite a bit in employment law, we're a full service firm. The bulk of our client base involves healthcare professionals, medical practices, and so forth. So this presentation we are tailoring for you folks. And as in the disclaimer, anything that we are stating today is not to be relied upon as legal advice or to create an attorney-client relationship. It is just to provide an update as to what the new laws are, and the topics for today are as follows. So first, Mitzi mentioned as she's working with you folks, a lot of the healthcare practices are asking questions on whether or not vaccinations are mandatory and whether or not they can be required. So we will discuss that first. And there are a number of new laws for 2021 that are related to COVID-19. So we will discuss all of those today. So the second topic will be workers' compensation, paid sick leave, workplace safety. Then we will discuss leaves of absence and worker classification. We will also discuss the new laws surrounding discrimination, harassment, and retaliation protections, privacy laws, and the new wage and hour laws. So currently, COVID-19 vaccines, I know it's more available for healthcare professionals. And the question that is arising with a number of clients is whether or not employers can mandate that their employees be vaccinated. And the law that governs this is the Equal Employment Opportunity Commission. And guidance is provided through the following: the American with Disabilities Act, Genetic Information Discrimination Act, Title VII of the Civil Rights Act, the Pregnancy Discrimination Act, and FEHA, which is the Fair Employment and Housing Act. So the answer to the question whether or not an employer can require vaccinations to ensure employees don't pose a threat to health and safety is that technically, yes, an employer can have a qualification standard under the American with Disabilities Act, which includes a requirement that an individual shall not pose a direct threat to the health or safety of individuals in the workplace. However, there is an exception, as there always is in the law. And the exception is that this requirement cannot screen out individuals with disabilities. So if an individual employee cannot be vaccinated due to a disability, the employer cannot exclude the employee from the workplace or take any other action unless there is no way to provide a reasonable accommodation, absent undue hardship that would eliminate the risk. And to show undue hardship, it is quite a substantial burden. So the employer will be required to accommodate the request of an employee if they cannot be vaccinated due to a disability. And there are a number of accommodations that an employer should look at. And if there's any confusion or concern, there is a website that employers can go to. It's called the Job Accommodation Network website for different types of accommodations. In addition, managers and supervisors are reminded it is unlawful to disclose that an employee is receiving a reasonable accommodation or retaliate against an employee for requesting an accommodation. So if an employee says that that employee cannot be vaccinated due to a disability, that information cannot be disclosed to other employees, nor can the employer try to remove that employee from the workplace or discipline that employee or reduce work hours for that employee. In addition, if the employer requires an employee to receive the vaccination and asks pre-vaccination screening questions, these are subject to the ADA standards for disability-related inquiries. So if these questions relate to genetic information, they must not violate Title II of the GINA. So that is the governing agency, governing act related to genetic information. So pre-vaccination medical screening questions are likely to elicit information about a disability, raising the potential for claims of disability discrimination. Screening inquiries must only be job-related and consistent with business necessity. So if an employee refuses to answer questions and therefore does not receive the vaccination, the employer may exclude the employee only if the employee would present a direct threat to the health and safety by not receiving a vaccine. So there are very, very narrow circumstances where the employer can use genetic information to make decisions related to terms, conditions, and privileges of employment. Another way that an employee can avoid being vaccinated is if that employee has a sincerely held religious belief that prevents the employee from receiving the vaccination. In that case, the employer must also provide a reasonable accommodation unless it would pose an undue hardship. There is always an obligation for the employer to try to accommodate the employee. And so an undue hardship under Title VII of the Civil Rights Act means that it cannot just be an economic issue. It cannot be more than a de minimis cost or burden on the employer. So if there is some type of reasonable accommodation that can be made, it is the employer's obligation to provide that. All right, so now the second topic that is of great issue currently is the FFCRA expiration and what the governing COVID-19 leave laws are as of January 1st, 2021. So when COVID-19 hit, there was actually a presentation that I provided to RCMA and San Bernardino Medical Society members. And the focus of that presentation was on the Families First Coronavirus Response Act. And in fact, there were a number of participants, I think it was over 300 participants. And then lo and behold, a few weeks after that presentation, the law was clarified that any healthcare providers and emergency responders could be excluded. So a lot of clients were then making a decision whether or not to follow the Families First Coronavirus Response Act or not. And if you are a healthcare provider or an emergency responder, there was no specific requirement. However, on September 9, 2020, California passed something called the Supplemental Paid Sick Leave Law, known as Assembly Bill 1867, which extended supplemental paid sick leave for employers that were not covered under FFCRA. So in that situation, that did include healthcare providers and first responders. Now, both of those acts have now expired. So as of December 31st, 2020, both of these paid leave acts for COVID-19 expired. However, there is a recently passed stimulus bill that allows a provision for employers to voluntarily give paid leave benefits through March 31st, 2021, so that the employers could receive tax credits as they have been doing in the past 9 months. But today what we will focus on, since those acts have expired technically, is the current Cal OSHA Emergency Temporary Standards Act. So this is effective as of January 1st, 2021, and it's set to expire on October 2nd, 2021. This, known as the Emergency Temporary Standards, ETS, it applies to all employers, employees, and places of employment, including healthcare providers and emergency responders. So the only category it does not apply to is for employees working from home or those who do not have contact with other people. Now, this is quite an onerous requirement. And the reason it is onerous is that employers are required under this act to not only create, but to implement a COVID-19 prevention program. This is a written policy program that all employers must have, including medical practices, since healthcare professionals are not exempt. Pursuant to this act, employers must identify COVID-19 hazards with input from employees and correct any such hazards, conduct tracing following any positive case that involves potential workplace exposure, notify and provide testing to potentially exposed employees, require physical distancing and mask wearing, improve ventilation and maximize outdoor air, not allow workers with COVID-19 who are at high risk of exposure to return to work until the quarantine ends, and provide paid leave to all quarantined employees throughout their quarantine up to 14 days. In addition, there is a reporting requirement of all outbreaks to the local public health department, which is defined as 3 or more cases in a 14-day period. In addition, providing continuous testing in the case of an outbreak, and in addition, screening workers before employer-provided transportation. Now, I think the most significant part, this is quite a comprehensive act, is the employer's obligation to have a COVID-19 prevention program. There is such a model program on the DIR website as set forth in this presentation, and the website address is listed here, but that is quite extensive, and it's not specifically tailored to an individual employer's business. So one of the things that we've been doing for a lot of our clients is actually preparing a COVID-19 prevention program that complies with these requirements and is tailored to your specific medical practice as to what's required, including who the point of contact would be for identifying, evaluating certain issues, the communication system. There's a communication system that must be detailed for reporting symptoms and exposure. In addition, this COVID-19 prevention program must implement effective policies and procedures to correct unsafe and healthy conditions. As medical practices, I am sure you are already all following these policies and procedures. However, it may not be in writing, and that is actually required at this time. In addition, providing and ensuring workers that they wear face coverings, reporting, record keeping, and access, providing effective training and instruction to employees on how COVID-19 is spread, infection prevention techniques, and information regarding COVID-19 related benefits that would affect employees. So in terms of the addendum, so what we have also done is for our clients that already have employee handbooks, the way this COVID-19 prevention program is implemented is through an addendum to the employee handbook. In addition, under Cal OSHA's emergency temporary standards, the employers must follow requirements for testing and notifying public health departments in the case of workplace outbreaks, major outbreaks. In addition, employers must offer COVID-19 testing at no cost to the employees during working hours if they've had a potential COVID-19 exposure in the workplace, and provide them with information and benefits on the benefits. Notification requirements to the local health department are to be no longer than 48 hours of learning of more than 3 or more COVID cases. Record keeping and reporting must be kept very in detail. However, that information must be confidential. So records must be available to employees with any personal identifying information removed. So a way that can be done is if the employees have identification numbers or something that would not specifically identify who that individual is, but just so that it can be notated as to whether or not and how many COVID cases have taken place in the workplace. When a COVID-19 related serious illness or death occurs, the employer must report this immediately to Cal OSHA, to the local district office. In addition, the key here is that whereas previously under FFCRA, healthcare providers were exempt, now if any employee at the medical practice is exposed to COVID-19 and the exposure is work-related, which the presumption would be that it is work-related, and we'll discuss that next, and that they must be excluded from work, the employer must continue to pay the employee's pay and benefits through the period of exclusions up to 14 days. In addition, there is a requirement that employers may potentially need to filter recirculated air with a high efficiency filter, which, and that is, there is a requirement of a minimum efficiency reporting value MERV of 13 or higher. And if their air quality ventilation system is not compatible, then the employer should use whatever the highest compatible filtering efficiency is possible. So if your medical practice is a tenant in a building, this should be reviewed with the landlord. That's something that we have addressed with our landlord in our building. And if you are a landlord, you do need to review these regulations and make sure that the ventilation system is compliant. Now, this is the next thing we're going to discuss is Assembly Bill 685. So Assembly Bill 685 should be reviewed and incorporated in conjunction with the OSHA temporary standards that we just discussed. So these requirements are for employers to notify in writing to their employees. So this is not just an oral notification. This is a written notification to employees of suspected and diagnosed cases of COVID-19, and also reporting workplace outbreaks of COVID-19 to local health departments. So within 1 business day, an employer who has notice of a potential exposure by a qualifying individual. So who is that? So somebody who has received a laboratory confirmed positive case or diagnosis from a licensed healthcare provider, has received an isolation order from a public health official, or who has passed away due to COVID. So this is 1 business day in writing. This notice needs to be provided to the employees that the individual was at the work site, and whoever is there during that infectious period of any employee who may have been exposed. In addition, the employer must provide those individuals information regarding COVID-19 related benefits, including workers' compensation, COVID-19 related leave, and paid sick leave, as well as the employer's anti-discrimination and anti-retaliation policies. So these need to be in writing. I strongly encourage any medical practices that do not have an employee handbook to consider immediately getting one prepared. The Cal Chamber provides that service. Our law firm provides that service. And it is very significant because of these new requirements. An employee handbook would already have anti-discrimination and anti-retaliation policies built into it. In addition, those individuals need to be provided with copies of the company's COVID-19 disinfection protocols and safety plan that the company plans to implement according to the CDC. The law also expands Cal OSHA's authority to shut down a worksite if the agency deems it as an imminent hazard. Although the employer must report and provide this information to the other employees, the employer is still obligated to maintain the confidentiality of the infected person's private information. What this means is notifying possibly exposed employees only of the dates that the individual was at the work site, but not sharing any information which might identify the affected individual. And then if there's an outbreak at the same work site within a 14-day period, the employers must notify local health departments within 48 hours. All right, so leaves of absences and worker classification. This is the third topic. And the bill that we are looking at is the Senate Bill 1159. Now, this is quite interesting. And I know a lot of my clients are surprised at the ramifications of this bill, because a number of my clients have encountered situations where employees have COVID-19 and they have not reported it to their workers' compensation carriers. And now there's a mandatory reporting requirement that is retroactive back to July of 2020. So under SB 1159, this is codified and superseded Governor Newsom's executive order, which made the injury from COVID-19 presumptively compensable, and it applies to employers with 5 or more employees. So if an employee tested positive or was diagnosed with COVID-19 within 14 days after a day that the employee worked at a work site, there is a rebuttable presumption that the employee's COVID-19 related illness is an occupational injury that allows the employee to be eligible for workers' compensation benefits. Under this regulation, it imposes reporting requirements for employers. When an employer knows or reasonably knows that an employee has tested positive, the employer must report certain information to its claims administrator. So we're talking about claims administrators for workers' compensation policies. It is a misdemeanor in California to not have workers' compensation. Therefore, all employers have workers' compensation, should have workers' compensation policies. And even if any employee has tested positive and the employee has not made a claim, the employer is now obligated to do so. So employers must report to their workers' compensation claims administrator, not just orally, but via email or fax, when they are aware that an employee tested positive for COVID-19, whether contracted at work or not, within 3 days of when the date the employee tested positive, which is the date the specimen was collected. And this must go back to July 6, 2020. The employee names should not be provided unless the employee files a claim, him or herself. So what that means is you have to report to your workers' compensation administrator, carrier, that there are the number of employees that have tested positive for COVID-19, but you cannot provide the actual names of those employees unless that employee files a claim. So this applies whether or not they filed a claim or not. It doesn't apply to employees working remotely at home, and this must be tracked up until December 31st of 2022. So this is a long-term bill requiring compliance for the next 2 years. So it expires on January 1st, 2023. And if there's an audit, there's a $10,000 fine for each non-compliance. And if you have not done this, I strongly encourage you to do it, and it has to go back retroactively. Okay, now we're looking at the California Family Rights Act. So the California Family Rights Act used to only apply to employers with 50 or more employees. This is a new unpaid leave act that applies to employers, all employers with 5 or more employees. So this allows eligible employees, this includes an employee that has worked for more than 12 months of service and at least 1,250 hours of service during a previous 12-month period, to take unpaid job protected leave for a variety of reasons. This can include the employee's own serious health condition, new child bonding, to care for a child, parent, spouse, domestic partner, grandparent, grandchild, or sibling with a serious health condition. So this has been expanded not just by expanding it to all employers from the 50 or more employers, but to grandparents and grandchildren, and that was not in the prior law. And this also includes covered active duty or call to recovered active duty for an employee's spouse, domestic partner, child, or parent in the armed forces. And it eliminates an exception that allowed employers to deny CFRA leave to otherwise eligible employees who were not within 75 miles of the work site, and also refusing to reinstate key employees. So it's just broader. It's allowing more employees to keep their jobs in the event that they need to take the time off to take care of a sick family member. And under the prior law, if both parents were working for the same employer, only one could take the leave, and now both can take the leave. So the job is protected for 12 weeks. It is unpaid though. So what this means is that if you have an employee that needs to take this protected job unpaid leave and have job protection, that they would have to apply for financial support, not from you, not from the employer, but from the state. So it would be under SDI or paid family leave insurance benefits. This is something that will need to be updated in the employee handbook as well, the CFRA policy. So if you have less than 50 employees, I'm assuming you don't have this in your employee handbook. So this is a new law that will need to be listed as a policy in any employee handbooks for 2021. And something important to note and for employers is that CFRA, if you have 50 or more employees, it's not just CFRA that would apply. So then you would also have FMLA and PDL, and that could mean that your employee has job protected leave for up to 24 weeks, not just 12 weeks. All right, so let's take a look now at sick leave and kin care under Assembly Bill 2017. So it amends Labor Code Section 233 that gives employees the sole discretion to designate leave to take care of a family member. Whereas presently the law permits employees to use only half of their annual accrual of sick leave to care for a family member. So it's expanding the protections of leave issues in the paid sick leave law for the following: diagnosis, care, or treatment of an existing health condition, or preventative care for an employee, diagnosis, care, or treatment of an existing health condition, or preventative care for an employee's family member, and for various other specific purposes, including whether or not the employee has been a victim of domestic violence, sexual assault, or stalking. All right, now moving on to the workers' classification under Assembly Bill 2257. So over the last couple of years, there have been a number of new laws. Well, the laws regarding whether or not an employee is an independent contractor or an employee. The Supreme Court has something known as the ABC test, and that is the default standard of what an independent contractor would be designated for versus an employee. Basically, this law has created some exceptions. And under the ABC test, in order to defeat claims of misclassification, an employer has to show essentially that the worker is free from control and direction of the hiring entity and performs work outside the usual course of the hiring entity's business. And essentially that the worker engages independently of the business of the work performed of the hiring entity. So what the new law does is it has created some exceptions. There's a business-to-business exception. In addition, another exception is a single engagement business-to-business exemption. So even if the factors of the ABC test to show the worker is not an independent contractor makes that individual look like an employee, if that individual only had one engagement with that entity, then there's an exception for that. There's also something known as the referral agency exception. If there is a sole proprietor or business entity that refers business or individual services to clients. And then there's something also called the professional services exemption. All right, so now the fourth topic is discrimination, harassment, and retaliation protections. So under California's Fair Employment and Housing Act, it is unlawful for an employer to discriminate, harass, or retaliate against an employee or job applicant if they are in a protected class. So in addition, this includes age and disability. Now, this has been expanded. Okay, so now what we're talking about under Assembly Bill 2992 is that this also has been expanded to anyone who is a victim of a crime which has caused a physical or mental injury or a threat of physical injury. So this applies to employers with 25 or more employees, and it allows time off from work to seek medical attention for injuries caused by a crime or some type of abuse where that individual needs to obtain psychological counseling or mental health services. So if there is an unscheduled absence taken, the employee does get to keep that, there's job protection with that. This is another category that employers must be aware of. In addition, there is another Assembly Bill that employers need to be aware of. It's the Assembly Bill 1947, which extends the statute of limitations for Division of Labor Standards enforcement claims of wrongful termination. Initially, the statute of limitations was 6 months after the occurrence of the alleged violation. Now, under Assembly Bill 1947, employees have 1 year. So this has extended the statute of limitations with the DLSC. In addition, it has amended the labor code to include a provision that allows an award of attorney's fees, reasonable attorney's fees to a successful plaintiff. There is a duty for employers to reasonably accommodate employees due to a COVID-19 disability. And COVID-19 does qualify as a bona fide disability protected under FEHA, which triggers the employer's duty to engage in the interactive process. So if you have 50 or more employees, you would also fall under the federal laws as well. And so although the Families First Coronavirus Act does not apply, the FMLA would apply, and the employer must reinstate employees to their prior positions after returning from leave. All right, we just have 4 minutes left, so I am going to briefly talk about the California privacy laws, which require employers to provide notice to employees of what information will be collected during health screenings or temperature checks, and to take reasonable security measures to safeguard that information. So information about employees and their family members falls under this category of personal information. And employers must provide employees with notice, a written notice. And if you are collecting information related to temperature checks and so forth, and you don't have this notice, please do not hesitate to contact me. I'd be happy to share that notice that you should be providing to your employees. This is required when personal information is being used, whether it's collected for self-screenings or so forth. And failure to comply with the notice requirements may subject an employer to civil penalties from $2,500 if they didn't know that they were supposed to do it, to $7,500 for an intentional violation. So there's really no way to get around this one. And if you don't have this notice, feel free to contact me. Now, there were some exceptions to this. Essentially, there were a couple of assembly bills that were signed into law. Some exceptions, however, as of January 1st, 2021, these exceptions do not apply. Therefore, all employers must provide compliant notices of consumer privacy protection. All right, just a couple minutes here. The new wage and hour laws. So if you have 100 or more employees, actually, let's just quickly go to this one. This is Senate Bill 1384. It expands the Labor Commissioner's discretion to represent a claimant who is unable to afford their own counsel, and it includes arbitration proceedings in there. And then another bill that has come out is Assembly Bill 3075. And if there is an outstanding final judgment by the Division of Labor Standards and Enforcement, anyone who is filing a statement of information must list that on the statement of information. So it must provide that information going forward. Now, there's a Senate Bill 973, which has just come out, which requires private employers with 100 or more employees to submit new data and information for the annual paid data report to the Department of Fair Employment and Housing related to the number of employees in certain race, ethnic, and sex categories. And I know there's a lot of new information coming out. So a lot of employers are struggling to understand exactly what is required. So there are updates and basically questionnaires with answers on the DFEH website. So if you have 100 or more employees, it is important to go online if you have any questions, as these are constantly changing. The guidelines are changing quite a bit. Finally, we've got the California minimum wage increase. So 2021, if you have 25 employees or less, the hourly rate now is $13 per hour. If you have more than 26 employees, the minimum wage is $14 per hour. If you have exempt employees, so those would be employees that fall under the executive, professional, administrative exemptions, then they must get paid a minimum of $58,240 a year as their salaries. So this is something that all employers need to comply with as of January 1st, 2021. And just a sort of checklist for medical practices to provide a safe and healthy and legally compliant workplace. It's important to look at government websites for updated laws and regulations, industry-specific guidance, perform a detailed risk assessment, create a worksite-specific protection plan. And all of this can really be done if you have a proper employee handbook with a COVID-19 addendum that has the plan that's required by OSHA. So some resources that are available, which we recommend that all employers check. So San Bernardino has a COVID-19 response website, so does Riverside County and the state agencies as well. along with Cal OSHA and the Labor Commissioner's Office. And then federal agency websites include the CDC, U.S. Department of Labor, EEOC, and OSHA. And this information can be provided as well from Marketia if anyone needs these slides. In addition, what else? And that's pretty much it. So it's important to check the industry-specific guidance for healthcare facilities as well. And that website is listed on this final slide. So if anyone needs any help, we have been working with RCMA for a number of years as a preferred business partner. We do provide complimentary consultations, and if more substantive work is required, we do provide specific discounts because of the relationship with RCMA. And so specific discounts are provided for members as well.
With that, I'm going to dismiss you all. Have a beautiful day.
Have a great day. Thank you.